Your Honor, my name is Paul Pataka. I was the fire investigator of the fire that occurred at 614 May Street the afternoon of March 27th, 2021. I ask that the evidence that was found be admissible in the trial proceedings and shown to the jury. The evidence and observations that were found inside the structure included the house appearing to be staged with old furniture and a broken television. Personal items from the house were missing. A melted device was found in plain view near the broken TV, and as the device was being collected, a marking on the floor that resembled a pour pattern of a flammable liquid was observed from the living room to the kitchen. All of these things point me in the direction that an arson fire has occurred here. According to the report from the lieutenant who was first on scene, the bulk of the fire and smoke were coming from the area of the living room where the TV, device, and pour pattern were all seen. The collection of this evidence was not a violation of the property owner's Fourth Amendment rights due to the exigent circumstances that surrounded the fire crew's departure from the scene. As the lieutenant, who was on scene awaiting the arrival of the investigator, completing paperwork, the crew was reloading the hose, dispatch issued a full alarm assignment to a structure fire with children trapped inside 3 blocks away from their current location. The crews on scene at 614 May Street have the duty to act and had to respond to that fire, thus leaving the scene of 614 Mays until I arrived shortly thereafter to conduct my investigation and finding said evidence. This was a continuing investigation of the fire. It is best practice to wait until an investigator arrives on scene to transfer the chain of custody, but that situation could not have happened here. In Michigan v. Tyler, 1978, the time between extinguishment and entries made to conduct an investigation was 4+ hours due to the exigent circumstances of the scene and also the need for a reasonable amount of time to be given for the investigation. The time between the lieutenant's departure to rescue children from another fire scene and my arrival at 614 Mays was negligible. Considering the evidence that was found, nothing would have had time to change after the initial fire and my arrival on scene. The old, rundown furniture that was inside the home could not have been moved in or out in the time the property was unsecured. The melted device that was noticed in plain sight, as well as the pour pattern on the floor near the TV and kitchen, could not have happened at any other time. Referencing Michigan v. Clifford, there is no requirement that a search warrant be obtained to search a fire scene for the purpose of determining its origin and cause. As this investigation happened within a reasonable amount of time after extinguishment, all evidence found therein should be admitted. In Michigan v. Tyler, 1978, the Supreme Court recognized that if there are exigent circumstances, such as reason to believe that the destruction of evidence is imminent, or that a further entry of the premises is necessary to prevent recurrence of the fire, no warrant is required and evidence discovered is admissible. Also in the case of Christian Reed Smith versus the state of Idaho, it was determined that under the exigent circumstances exception, agents of the state may conduct a warrantless search when the facts known at the time of the entry, along with reasonable inferences drawn thereupon, demonstrate a compelling need for official action and no time to secure a warrant. It is my assertion that a warrant wasn't needed for this investigation, and no Fourth Amendment rights were infringed upon due to a reasonable amount of time needed to arrive, conduct the fire investigation, and exigent circumstances the fire crews had. Thank you.